begin this discussion, we said it's a media engagement, right? It's an engagement, and I'm already happy and excited by the tone that we have set for this engagement. We are here to frankly talk about this piece of legislation, which is the Cyber and Data Protection Act itself. We are here to discuss the opportunities and the challenges that it presents for our nation. We are here, really like Mrs. Lukota has indicated, to share ideas on how best we can implement the provisions of the Act. And I'm happy that in this room, we have the key stakeholders that are involved in the implementation of the Cyber and Data Protection Act. We have Potraz itself, which has been designated as the Data Protection Authority of Zimbabwe, being the regulator responsible for regulating the conduct when it comes to the processing of personally identifiable information, which translates to the manner in which we collect other people's personal information, the manner in which we use that information, the manner in which we store that information, the manner in which we share it with other people, the manner in which we publish it, the manner in which we transfer it beyond the borders of Zimbabwe, even including the manner in which we destroy that personally identifiable information. So this is the whole discussion that we are going to be having today. And I said we have Potraz, the regulator. We also, in terms of the agenda of this meeting, I just want to say we are going to be joined by our Director General, I think a few minutes from now. So when he comes in, or when he comes to officially open this meeting, which is very dear to him because he has been on our back to say, let's engage the media, let them understand their role when it comes to the Cyber and Data Protection Act, let them understand their obligations, let them also understand their rights, let them understand the boundaries in terms of their role within the framework of the Cyber and Data Protection Act. So the agenda is packed. We have a lot to discuss with you. I wish we had more days, but these are some of the items of the issues that I'm going to be sharing with you today to understand what this piece of legislation is all about. So last week, I had the opportunity of learning one philosophical framework which is called deontology. And when I learned about this philosophical framework called deontology, which is all about, it's got different parameters, but one of the parameters is that do unto others what you want them to do unto you. There is a duty that we all have towards each other. Then the second aspect of the theoretical framework, which I'm really interested in, is also that intention is very critical in every activity or in everything that we do in our lives. So I'm bringing this theoretical framework for us to understand the duty that we have towards others. It doesn't matter whether you're a legal practitioner, you are a media professional, you are an accountant, or you are a police officer. There is a moral duty to do unto others what you'd want them to do unto you. And the second part is the aspect to do with intention. That your intention is the most important thing in whatever decision you take or in every activity that you do. What was the intention? Don't worry about the outcome or the result, but what was your intention when you performed a particular task or when you did a particular activity? So I wanted us to look at that second aspect, which is the intention. What was the intention? Why are we having this conversation? Why are we even engaging in this discussion as a nation, in this discussion as stakeholders, that is the journalists, the police, and Potraz as the Data Protection Authority of Zimbabwe? And the intention of the legislature in 2021 was actually premised on the fact that it was no longer business as usual in Zimbabwe. The context, the environment within which we were operating had differed. We were moving towards a digital economy. And when you look at the statistics themselves, and the source is Potraz, I think we're a credible source. We are looking, just to look at the statistics from 2015, look at our internet penetration rate as a country. Look at our mobile penetration rate as a country. Look at our fixed penetration rate as a country, even the fiber penetration rate. So we were an economy, or we were a country where the issue of the cyberspace at that point in 2015 didn't raise many concerns or big issues for us to really think or start to think about making sure that we have a digital governance framework, or we have a framework within which we need to govern the conduct of people on the digital space, or particularly when it comes to the manner in which we collect and share other people's personally identifiable information. So when you look at it, almost every Zimbabwean now, we are at 82.87% in terms of the internet penetration rate. So we are looking at over 16 million Zimbabweans having access to the internet in Zimbabwe. And the import of that, or the implication of that, is that we have more and more people engaging on the cyberspace. We have more and more people who are using different digital devices to talk to each other, to communicate, even to do journalism using those different devices that we have. So I wanted to look at the fact that we need to look at the intention of the legislature. So as we were building the digital economy, can you still hear me? Okay, it's still good? Okay. So when you look at this digital economy that is constantly growing, as more and more Zimbabweans have access to smart devices and digital devices, we couldn't remain with the status quo where we didn't have a digital governance framework or a digital governance tools. We were like a country or a person who is building a house with no windows or doors. So we are allowing every Zimbabwean to have universal access to communications, but we didn't have the safeguards to make sure that when they engage on the internet, when they engage on the cyberspace, there is a framework within which they can actually be protected, or there are guardrails and safeguards in place to make sure that we deter abuse of use of the internet. We also deter abuse of people's personally identifiable information. So I just put up those statistics for us to see that indeed, the more we are digitalizing as an economy, the more we need the safeguards, the more we need the guardrails to make sure that we balance the interest or the rights of every citizen in Zimbabwe. I thought it's also important, setting the tone for our discussion, to think about some of the misconceptions we have, or the understanding, and I'll start with the misconception that was shared by, in the experience shared by Dineo, that Section 164C is under the Cyber and Data Protection Act. That's the first one. Section 164C is under the Criminal Codification and Reform Act. And that law is not administered by Potraz, it is administered by the Ministry of Justice. And over and above that, the provision that he mentioned or spoke about exists in our criminal code and not in the Cyber and Data Protection Act. I'm going to explain further the relationship between the Cyber and Data Protection Act and the criminal code so that you understand why we are having this misconception and your role as the media to provide accurate information on the status quo. So, that's the first one, but I had prepared this one to say some people amongst ourselves, we have the misconception that the Cyber and Data Protection Act does not apply to the media. The media is exempted because Potraz, through the Ministry of ICT, Postal and Courier Services, has provided for the exemption from licensing for journalistic purposes. So the misconception that then kicks in is that the journalists or media houses are exempt from licensing with Potraz. They are exempt. There's a blanket exemption for journalists in terms of the application of the Cyber and Data Protection Act. But the reality itself is that everyone in Zimbabwe who collects, whether you are an individual, you are a media house, you are a bank, you are a pension company, you are a retailing shop or a retailing company, you are required by the Cyber and Data Protection Act to follow and adhere to the principles that are contained in that piece of legislation. So, media, you are not exempt in totality from the provisions of the Cyber and Data Protection Act. Why? Because as media houses, you collect people's personal identifiable information, and that makes you a data controller. And in terms of the Cyber and Data Protection Act, every data controller should actually be licensed by Potraz, and there are tiers that my colleagues are going to be talking about later on. So that's the first misconception that we need to address, that the Cyber and Data Protection Act is not targeting the media to make sure that journalists are put in jail. No. It is targeting every controller in Zimbabwe across all sectors of the economy to be transparent and accountable in the manner in which they collect and process other people's personally identifiable information. The second misconception is that there is a misconception that our government, through the Cyber and Data Protection Act, is actually banning people from collecting personally identifiable information, including the media. We are now banned. We are not supposed to be collecting people's information. And we are saying the Act does not prohibit anybody in Zimbabwe, including the media, from processing personal information. But what the Act has done is to set a framework of rules within which we can collect and use and process other people's personally identifiable information. And this framework actually emphasizes the fact that when you collect someone's personal information, you can't hack into their computer. It becomes an unlawful acquisition, isn't it? So we want to appreciate where we start and where we stop and our boundaries. Yes, you are a journalist. You want to exercise your right to freedom of expression. But do you have to hack into my computer to get information that you want to make sure that you exercise your freedom of expression? That becomes an unlawful acquisition. And I think this is where we need to appreciate and understand that as media professionals, as data controllers, when we collect personally identifiable information from individuals, directly or indirectly about individuals, we must ensure that we collect that information lawfully, in a fair manner, as well as taking into account public interest considerations. So it's important for us to understand. So no one in Zimbabwe is being banned from collecting personally identifiable information. But we are saying when you collect it, please protect it. When you collect it, please do so in a lawful manner. What is your lawful basis for collecting that information? For the media, for example, you could say it's in the public interest for me to collect that information so that Zimbabweans know the sector performance report in the telecommunication sector, for example, for the public to know that the Director General of Potraz is going to be presenting that sector performance report, because when you report about him, you have collected his name, you have collected his address, you have also collected his status in society, which becomes personally identifiable information, as you are going to see later on. So I'm just talking about these misconceptions and the reality so that we set the tone for our discussion. Then there is another one. It says, like Tinoyo shared earlier on, that it is the worst piece of legislation, like he said, which curtails journalistic freedom and has resulted in the arrest of 9 journalists. That is a misconception, because the Cyber and Data Protection Act does not speak to the provisions you are speaking to. Cyber and Data Protection Act has sections 1 to 34. So the moment you start to talk about the fact that section 164 of the Cyber and Data Protection Act, then that is a misconception, because that one is contained in our criminal code, okay? So the reality really on the ground is that the Cyber and Data Protection Act itself is focused on issues to do with how we govern the data that we collect to be able to transact in our industries, in our businesses, or in our responsibility as the media, with the appreciation and understanding that media freedom is a constitutional right that is provided for in Zimbabwe, and therefore it is also a constitutional right which is not absolute. there are limitations to it. And we all know Section 65, Section 85 speaks to the limitations. It ceases to be freedom of expression or freedom of the media when it incites violence, and that's in our supreme law of the land. And those are some of the limitations I think that MISA is also going to be sharing with you, that these rights that we are talking about, whether it's media freedom, is not an absolute right. Likewise, the right to privacy itself is not an absolute right. There are certain limitations also which we are going to be sharing with you. So responsible journalism is actually something that is not criminalized by the Cyber and Data Protection Act. Then the other issue that I heard some of the media professionals complaining about, that you want us to do a report and we have to get your consent first before we publish your article. And I just want to say that's a misconception as well. Because as the media, right now as I'm speaking, you can collect my name and surname and start to write an article. You don't have to get my consent. Why? Because it is in the public interest to understand that the Director of Data Protection, Ms. Tsitsi Mariwo, was speaking at a media engagement workshop. It's in the public interest because your role as journalists is to make sure that the public have access to accurate information about a particular issue that affects them or has an impact for the public interest itself as in totality. So consent is not always required when you are doing your journalistic work, because you are protected by the limitation that when you are doing this work for journalistic purposes and it is in the public interest for the public to understand and know what is going on in our economy, what is going on in the telecommunication sector, you don't necessarily need my consent to do so. There are other legal bases that you can actually use, and one of those legal bases is that you use the defense of public interest. But you need now, as you will see in my recommendations, in your different media houses, to make sure that you document, you have policies in place that actually help you to determine what is in the public interest, that help you to see whether you have followed the different steps in your policies when it comes to those stories that are intrusive in nature. But you are not stopped from reporting those stories by the fact that you need consent from someone. So that is something that I also wanted to say, that journalists do not necessarily need consent, but not just journalists, but even other entities. There are other legal bases that are required or that can be used to actually process personally identifiable information without getting the consent of the data subject. Then the other issue, we had an engagement, an informal engagement with other media professionals, when I said, no, but as media, you are exempted from certain principles of the cyber and data protection or their application to the media itself when you actually indicate that it is in the public interest. And they were like, so as Potraz, you are the ones who are going to determine what is in the public interest. And no, we are saying it is the role of the media. It is your responsibility. You have your industry codes that help you to determine what is in the public interest. And even in your own editorial policies, you have provisions that help you to determine whether a particular story and processing someone's personally identifiable information to publish that story is in the public interest. So it is not the role of Potraz to help you determine what is in the public interest. The reality of the fact or the reality of the issue is that the assessment of public interest itself rests primarily with the media, right? And Potraz does not substitute your editorial judgment to say what is in the public interest and what is not. So what is just required is for you to be able to substantially justify that processing of Tsitsi Mariwo's information was in the public interest, and therefore we followed this policy that we have as a media house, which helps us to determine what is in the public interest. So I move on to the different global frameworks that are in place at the moment because Zimbabwe does not operate in isolation. I spoke about the issue of intent in the beginning. What is the intention? What was the intention of the legislature in actually coming up with the Cyber and Data Protection Act? We don't operate in a vacuum, and issues to do with data protection are now a global standard. They are a global norm. I remember back then, before the Cyber and Data Protection Act, institutions in Zimbabwe who were doing business with Botswana had challenges talking to their entities in Botswana to transfer data of Botswana people to Zimbabwe, because Zimbabwe didn't have a Data Protection Act. And because under the adequacy principle, you can only transfer personally identifiable information of a data subject to a country that has an adequate level of protection. So before 2021, Botswana didn't want to transact with us insofar as personal information of their people was concerned, because we didn't have a legal framework that protected the personally identifiable information of their people. Likewise with the European Union, our banks were being requested to adhere to the general data protection regulations when dealing with the data of EU citizens, because we didn't have a legal framework as a country. We only joined after 140 other countries had already drafted a data protection framework. I know I also understood last week but one, when Nestle was being asked to recall all milk products from the shelves. Why were they being asked to recall the milk products from the shelf? Not that there was anything defective in the milk, but it is because they had not followed certain sustainability standards in relation to ESG, right? Environmental, social, and governance issues. Because the milk was produced, the value chain of the milk production at some point involved the issue to do with the use of child labor. So when something becomes a global norm, like environmental, social, and governance issues being a global standard, you then risk being ostracized as a country from the global framework itself. You recall even issues to do with anti-money laundering. When we were not part of the anti-money laundering framework as a country, we were being cut off from the international financial system until we had to adhere with the anti-money laundering framework itself. So likewise with data protection, we were having those challenges where certain countries could not do business with us because we risked being an environment or a country which had no respect for the protection of the data of personally identifiable information of those people. So it has become a global standard, and globally, 82% of the countries in the world have a data protection framework, which is meant to deal and address issues to do with the manner in which we collect other people's personally identifiable information and do not abuse that information, but use it in a lawful, accountable, and transparent manner. So, at the African level, 64% of African countries have a data protection framework. I want us to position ourselves as a country within this global framework to say, we cannot exist in isolation. We transact with other businesses, we transact with other countries who are beyond the borders of Zimbabwe. And therefore, we have to adhere to global standards and global frameworks that are also in the interest of our own people, in the sense that when we want to transfer PII of Zimbabwean citizens, they achieve or they get the same level of protection that we are also giving to the citizens of those countries. At SADC level, 75% of SADC countries actually have a data protection framework in place. So I'm talking about intent again, the deontology philosophical framework that I started with at the beginning. That the intention was that Zimbabwe also meets the global standards in terms of the global norms in a digital environment. I'm still going on where we fit in within the African data protection architecture as a country, because we don't exist in isolation. We are a member of SADC, we are a member of the African Union, we are also a member of the United Nations. And therefore, whatever we do within that framework, we also have to align with some of the global standards, which have a bearing in the manner in which we address issues in Zimbabwe. So we all know we have National Development Strategy number 2, where we aspire to be a digitally enabled economy by 2030. But that digital economy by 2030 without safeguards, without guardrails like data governance frameworks is a disaster, because people will be abused on the cyberspace. Our personally identifiable information will be used without accountability, and that is what the Cyber and Data Protection Act seeks to actually address. So, at the African Union level, heads of states agreed that things are no longer as usual. We are moving in this digital terrain, digital space as Africa. There is need for us to have safeguards. So they came up with the Mariwo Convention in 2014, which is meant to protect personally identifiable information, but also to govern cybersecurity at a continental level. And we are actually required by the Mariwo Convention of the African Union to make sure that we harmonize our data protection framework with the rest of Africa. And the reason being that there is a lot of cross-border trade or cross-border transfer of personally identifiable information with regards to digital trade under the Africa Continental Free Trade Area and the Digital Protocol, where we are actually required as a country to make sure that we have in place a data protection framework that ensures when data of a South African flows to Zimbabwe, because we are always flowing to South Africa as Zimbabweans, isn't it? We do shopping in South Africa, isn't it? Our data is flowing. Our banking details flow to South Africa. When a foreigner visits Zimbabwe, their data flows to Zimbabwe, isn't it? Our immigration has access to that data, isn't it? Home Affairs has access to that data, for example. Likewise, we cross the borders. South African immigration has our information. So as the cross-border is happening, e-commerce, we buy a lot of things from South Africa online. We buy in the US online. There's a lot of, we buy from Kenya online, for example. So there is always the transfer or the flow of data across different borders. And it was therefore important at African Union level to agree that every country in Africa must be ready, what they're calling digital trade readiness. And one of that requirement is that we have a data protection framework that ensures when data flows in Zimbabwe of our citizens of other countries, it receives protection, that they also reciprocate to the data of Zimbabweans who go beyond Zimbabwe. And in that respect, we know that a lot of data flows to South Africa. The Data Protection Authority itself has actually entered into a bilateral arrangement with the South African Information Regulator to make sure that when data flows into South Africa and into Zimbabwe, we reciprocate in terms of the level of protection of personally identifiable information of our citizens. Even at SADC level, we actually have a SADC model law which was developed way back in 2012. And in that SADC model law, it's the same data protection principles that we have as a nation, wherein we are saying there must be lawful processing, there must be fairness in our processing, there must be accountability in our processing, there must be transparency in our processing, and we must secure the data that we collect. You can't be collecting other people's information and you leave it lying around everywhere. So I'm going to be sharing with you some of the principles also that as data controllers, because as media houses, in terms of the Cyber and Data Protection Act, you are data controllers. You determine the means and purpose of processing personally identifiable information. You are the ones who say, for this event, I want a marital status, I want the number of children that she has for you to be able to publish the story. We also want to understand her academic qualifications for us to publish the story. So you determine the purpose. You even determine the data that is to be collected. And you determine how it's going to be collected. No, we want to do a video with her. You are determining the manner in which it's going to be collected. Or you are saying, Miss Mariwo, let's have your presentation. You are also determining the manner in which you are collecting personally identifiable information. So as media houses, that makes you data controllers. And under the Cyber and Data Protection Act, you are required to meet certain obligations and certain principles in terms of the law. So SADC actually expects right now 12 of the 16 SADC member states have a data protection framework. The others 4 are actually having their draft legislation being passed before Parliament this year and probably some next year. So at SADC level, we have actually taken a step further. Last year in Zimbabwe, we were the chair of SADC, and our minister chaired the SADC Ministers of ICT meeting. And one of the resolutions from that meeting was that at SADC level, we need now a data governance body that is responsible for bringing together the data protection authorities in SADC to sit down, to harmonize our laws, to harmonize the manner in which we transfer data, to harmonize the manner in which we institutionalize the whole aspect of our data protection within the different institutions in our country. So, to sum it all, the data protection framework itself enables trust in the use of information communication technology. It actually secures the digital transformation agenda of our country. Otherwise, we'll be such an irresponsible country to say, let every Zimbabwean have a gadget, but we are not helping them to protect themselves when they are using that particular gadget. So this is the whole essence of the Cyber and Data Protection Act. It's important to talk about the policy framework. I spoke about NDS2, and there is actually a specific provision under the digital pillar, what they are calling the Science, Innovation and Technology pillar, and that's where we fall in as Potraz, being the Data Protection Authority of Zimbabwe. It actually specifies, I took it verbatim, that NDS2 will prioritize cybersecurity, governance, and operational readiness by all institutions in Zimbabwe, including the public sector. I'm sure you saw one of the videos where even the Ministry of Defense acknowledges that they are not above the law. They have licensed with Potraz. They've trained a data protection officer because they understand that there is need to go beyond the traditional defense that we were used to, the physical traditional defense. We also need to defend the nation on the cyberspace, and which is why they've actually complied with the law. So NDS2 is actually saying it's going to prioritize the enforcement and implementation of laws and regulations governing cyber and data protection to create a robust framework. So my apologies there for the spelling. Institutions will be required to strengthen cyber resilience because cyber threat actors are on a prowl. There are a lot of cyber incidents, as you'll see from the presentation that will come. So there is a need to safeguard national data and maintain public trust in the digital operations of different institutions. We also have our national ICT policy, which speaks to the fact that we need to promote confidence and security in the use of ICTs. We need to join other nations to standardize our data protection laws. We also need to promote international and regional cooperation. There is no way we can have international and regional cooperation without a framework which is a global standard or norm. Before, we had no bilateral agreement with South Africa because South Africa had their POPIA Act, which is an equivalent of our Data Protection Act in 2013. But we could not have a bilateral arrangement to protect the data of Zimbabweans because we didn't have a reciprocal piece of legislation to protect their own citizens. So our national ICT policy is also encouraging international and regional cooperation in securing the internet. I come on to, I've talked about the policy framework, and it's important for us to interrogate what informs the Cyber and Data Protection Act itself. And I would say that it is informed by Section 57 of our Constitution. So the supreme law of the land speaks to the fact that everyone has the right to privacy, which includes freedom from unlawful searches of their person or their home, protection from having their possessions searched, right against unlawful interception of their communication, right to have their personal information safeguarded and not to be disclosed unlawfully. So that is what the supreme law of the land is providing. Section 57, every Zimbabwean citizen's right to privacy. So that's the default position in terms of the constitutional provision. That's a right. But like I indicated in my opening statement, that right in the Constitution has got limitations, or there can be derogations from that right in the public interest, where you come in as journalists, so you can derogate from the right to privacy if you want to publish a story in the public interest. There are those derogations as well when it is in the national interest, in the security or national security interest of the nation. It is also something that we need to think and talk about when you look at the limitations. So, when the constitutional framework provided for Section 57, Parliament saw it fit to have a piece of legislation, a primary legislation, that would give effect to Section 57 of the Constitution. Because in the Constitution, this is all you find. But then how do we operationalize that? That's when now we have the Cyber and Data Protection Act and the accompanying regulations, which we call Statutory Instrument 155 of 2024, on how to license those who have the potential of infringing on the right to privacy. How we can put in technical and organizational measures so that institutions can protect the right to privacy. So the Cyber and Data Protection Act is the machinery that has been put in place by Parliament, the legal framework, the primary legislation that gives effect to Section 57 of the Constitution. And we're still developing regulations, we're still developing guidelines so that we all understand from the different sectors our requirements or our obligations in terms of the Act. So, when you look at the Act itself, we want now to dispel the misconceptions, right? This Act, when you look at the objects, if there's someone looking at the Act right now, the objectives of this Act, it is an Act to provide for data protection, not to the arrest of journalists, please. It is an Act to provide for data protection with due regard to the Declaration of Rights under the Constitution and the public and national interest, right? So you have this right to data protection, but it can only be exercised with due regard to other rights in the Constitution, which include journalists' right to freedom of expression or to the freedom of the media. So there is a balancing act that needs to be done there, whether from a law enforcement perspective or from a regulatory perspective. So it is an act which is providing for data protection with due regard to the Declaration of Rights. The legislature understood that this right is not absolute. There are limitations to the right, and those limitations are clearly spelled out in Section 86 of the Act. That certain rights in the Constitution are not absolute. There are also certain rights that are required to be absolute. But one of those rights that is not absolute, that is subject to limitations, is the right to data protection or right to privacy. The object of the Act as well is to build confidence and trust in the secure use of information and communication technologies by data controllers, whom I've defined earlier on and which my colleagues are going to define even further. They are representatives as well as the data subjects. This Act seeks to create a technology-driven business environment which acknowledges that we need to technologically advance as a nation. We need to be a digital economy as a nation, but we do that through the lawful use of technology. Because if technology does not save us, why do we need it? It has to save us. And there shouldn't be abuse in terms of use of that technology, including abuse of people's personally identifiable information. So those are the objectives of the Act. I hope as we are going through this presentation, we are actually dispelling some of the misconceptions. So the subject matter, please take note. The subject matter of this piece of legislation is to protect personally identifiable information of a living individual. Okay? Is to protect your personal data. And what is that personal data? It is your name, your address, your telephone number. I've listed all those things, your fingerprints, your health information, your marital status. That is what we call personally identifiable information. And this is what this law seeks to protect from abuse, or from unlawful use, or from an unaccountable use of someone's personally identifiable information. Because in our nation, we need people's personally identifiable information to transact, isn't it? Whether you are a bank, whether you're an insurance company, whether you're a media house, you use personally identifiable information to recruit your staff, to deal with your media advertising agencies, to deal with your service providers. You are going to be collecting personally identifiable information, even for visitors who visit your offices. But we are saying, when you collect it, what are the safeguards that you must put in place to make sure that it is not lost, it is not destroyed, it does not leak to people who are not supposed to be having it, causing harm to the next person. So this is the subject matter: personally identifiable information of living people. Scope of application: to whom does it apply? It seems from the misconception that the Cyber and Data Protection Act is just targeting media houses or journalists. And yet we have now licensed over 1,000 data controllers. And from the 1,000 data controllers, 75% are actually banking institutions. We're talking of insurance companies. We're talking of local government, ministries, departments, and agencies of government. We're talking of educational institutions, and not just the media. So we need to dispel the misconception that this act is targeting the media. No, it is targeting every data controller, every person who determines the means and purpose for collecting personally identifiable information of a Zimbabwean or non-Zimbabwean when they transact their business. So it applies to entities, not just media houses. It applies to all entities, public or private organizations in Zimbabwe that are established in Zimbabwe, who process personally identifiable information, even including big tech, which may not necessarily be established in Zimbabwe, but has a means or an application that is being used to collect our PII as Zimbabweans. So this also applies to Meta. It applies to Google. It applies to WhatsApp, because they have an application which is here, which we have access to here, and which is collecting our PII. So in terms of this Cyber and Data Protection Act, they are actually required to designate a representative in Zimbabwe who will ensure that they are compliant with the provisions of the Cyber and Data Protection Act when they process the personal information of Zimbabweans. And already we have big tech, or we have international organizations like Uber. They've already appointed their representatives in Zimbabwe. We have several other international big tech that has also appointed their national representatives in Zimbabwe to represent them, to make sure that when they process personally identifiable information of Zimbabweans, they do so in a lawful manner and in accordance with the requirements of the Cyber and Data Protection Act. So I'm just going to fly through the key provisions of the Cyber and Data Protection Act. It is the primary legislation now in Zimbabwe governing how we process other people's personally identifiable information. Prior to this act in Zimbabwe, we had, scattered pieces of legislation or scattered provisions in different pieces of legislation, like the Health Act, the Banking Act, had provisions that spoke to the fact that when they transact with us as their clients, they must maintain the principle of confidentiality. But those pieces of legislation were not robust enough to look at the other data protection principles that are recognized globally. So it outlines the rules. So the important thing is just to understand the rules so that we avoid the misconceptions. The rules: how do I collect my neighbor's personally identifiable information? How do I collect my relatives' personally identifiable information? How do I collect my clients' personally identifiable information? How am I supposed to share it? How am I supposed to transfer it across the borders of Zimbabwe if I'm using cloud services? What security measures should I put in place to make sure that it does not leak to the wrong person who then eventually cause harm to them. That's what the data protection is all about. It also designated Potraz as the Data Protection Authority of Zimbabwe and provided its functions in Section 6. My colleagues are going to be talking about that. It also speaks to the internationally recognized by the OECD, by the United Nations, what we call the global data protection principles, that in any organization, in any country, these are the basic principles that we must adhere to when we are processing someone's personally identifiable information. It also provides for the rights of data subjects and the obligations that all controllers, including the media, your obligations when you are processing personally identifiable information. So these are the principles. Number one, you must have a lawful basis for processing personal information. And like I said already, as the media, you have a lawful basis already, which you are given in terms of the Constitution, which you are also given in terms of this law, which is the right for the public to know or to have access to information. So your role, you play it within the framework that as a journalist, I am acting in the public interest to produce a particular story. So that's a lawful basis already, which is provided for in the Cyber and Data Protection Act. Number two, when you collect, in that very same principle, when you collect personally identifiable information, you must do so in a fair manner. There are instances where you are required to inform that person that you are collecting their personally identifiable information. But when it comes to investigative journalism, you may not need to inform them. Otherwise, you won't get what you want to get, isn't it? So in investigative journalism, this is where you are required as media agencies to have policies, standard operating procedures, which guide you when you are dealing with very sensitive stories, but which are in the public interest. Transparency is also critical. When you have a story about me, I mean, if you have my phone number, what stops you as a journalist to just be transparent and check with me? In some cases, it's possible for you to do that. I know in some cases, when you are doing investigative journalism, it may not be. But in most of the cases, you can check certain information for its accuracy with me so that you don't publish inaccurate information about me. Because that is also another data protection principle, that as journalists, make sure what you publish is accurate. And it is a requirement also in terms of our Constitution that your role is to publish accurate, not inaccurate information about a person. So it is the fourth principle that is provided for in our Act. Purpose limitation. Your purpose is for journalistic purposes, or your purpose is for recruitment purposes, or your purpose is to defend a legal claim. So whatever the purpose that you have for collecting that information, it must be specific. And you must use that information for that purpose. For example, you can't say, I'm collecting your name, surname, marital status because I want to publish a story. And then after you have done your publication, you start advertising the cell phones you are selling in the other business using the same information. That would not be fair, because the purpose for which you collected my data was for journalistic purposes. And now you are using my data, which you collected for journalistic purposes, to start advertising the gadgets that you are selling in your other business. So that's a principle also that is not being allowed under the Cyber and Data Protection Act. Be clear with the purpose for which you are collecting data. Use the data for that particular purpose. Likewise with the police, when you collect information, my information for lawful, for enforcement purposes, you cannot then use that information, for example, for other purposes, to start advertising maybe other businesses that the police is doing or selling products to me as a data subject for whom you collected data for law enforcement purposes. Data minimization. Collect the data that is only necessary. For example, you want to publish a story about this workshop. Do you need to publish that Tsitsi Mariwo, the daughter of Zacchaeus Mariwo and Anna Mabo? Do you need to talk about my parents? So you have to minimize the data in accordance with the purpose that you seek to use that data for. So data minimization is critical. You even don't need to have my marital status. You just say Tsitsi Mariwo, Director Data Protection. Do you need to say female? So data minimization is really something that is also a principle that is provided for in the Data Protection Act. You can't even talk about my health status that I'm at a workshop. Tsitsi Mariwo, who is diabetic in nature, but also the Director of Data Protection, was making a presentation. So those are issues we need to know as the media. Those are issues we need to know as data controllers in our order. Because the police are also data controllers, and I'm glad that the police are also saying, Home Affairs is saying we're not above the law. They have sent their officers for training. And I believe in 2-3 years, we are really going to see a major difference in our enforcement approach when it comes to balancing the interests of journalists as well as the right to privacy. Storage limitation. After this workshop, Potraz, then 10 years down the line, you ask them, Kuti, what data do you hold about me? And then we tell you that the data is about a workshop you held at Golden Conifer 10 years ago. It won't be fair on you. So you need to keep data for as long as it is necessary in the format that you collected it. So sometimes for archival purposes, you then need to remove my name so that we just know that 300 people attended our workshop without necessarily saying it was Edith who was there, it was Mr. Majindu who was there, it was Tineo who was there. We just have a blanket, knowledge of how many people attended without having your names. So as institutions, as controllers, we need to exercise with caution when it comes to the principle of storage limitation. Of course, there are exemptions, there are derogations when it comes to law enforcement. For example, the police is also guided by their own act in terms of for how long they keep criminal records or they keep certain information. That is something that is totally different. So they have a lawful basis for keeping my information longer than is necessary, because law enforcement requires a certain level of understanding that until the prosecution is complete and up to a certain level, like sometimes for pedophiles, your record can't be, erased, because the people need to know you're a pedophile, because you're a danger to children. So there are certain limitations. That's why I'm saying these rights are not absolute. There are limitations. Integrity and security. You're a media house. You have collected our information here, for example. How many people were here? They were coming. Oh, there was such and such a person from Human Rights Commission, such. And then you have that information. You are just having it lying all over the place. You are not even securing it. So the principle of integrity and security of the data, when you collect the data, you must protect it. So make sure in your organizations you have access protocols. Who has access to certain information about certain individuals? Access control measures that make sure that certain offices or certain cabinets are supposed to be accessed by a certain person when it comes to issues of physical security. Then when it comes to access control on the cyberspace, who has access to certain information? So those are security measures you need to put in place to make sure not everybody has access to certain information that you have collected about a living person. Then looking at the issue of accountability, you must also be accountable in the manner in which you collect personal identifiable information. I would give an example of the media. Yes, you have a defense. You go and publish a story about me. I didn't give you consent, but it's in the public interest for people to know. But it is also important for you where my data has leaked to the wrong person, for example. I'll give an example. Maybe we have a courier company that is carrying my passport to an embassy in South Africa. They have a responsibility to make sure that as the data transits to South Africa, it is secure, it is protected. As it gets and comes back to Zimbabwe, it is also protected and secured. And in the process of transiting, either going or coming back, if something happens to my passport disappears, or it is stolen, or it is damaged, or it is destroyed, they should be accountable to me, as well as being accountable to the Data Protection Authority to say there has been a data breach of Ms. Mariwo's personal identifiable information. Their ID has been stolen. it has the potential of causing harm of identity theft, for example. So these are the obligations that we have in terms of the data protection principles. This is where a lot of the misconception is coming from. In Zimbabwe, when Parliament sees it fit to amend another piece of legislation, either they can do an overall revamp of that piece of legislation and republish it, or they can use another act to amend another act. So the Cyber and Data Protection Act was used to amend other 3 acts of Parliament, because at the time it was that law that was ready for enactment. And yet the Ministry of Justice needed to amend other pieces of legislation so that they also align with technological developments. So Parliament saw an opportunity using the Cyber and Data Protection Act to amend number 1, the one that is notorious, the Criminal Procedure and Evidence, the Criminal Law Codification and Reform Act, where a lot of misconception is emanating from. So the Cyber and Data Protection Act itself was used through what we call consequential amendments to amend other acts of Parliament. But that doesn't mean the Cyber and Data Protection Act is now that act of Parliament. So the sections that you are referring to, sections 162 to 166, which we are always seeing you citing as media, as journalists, as being an onslaught on your right to freedom of expression, are not in the Cyber and Data Protection Act. They are in the Criminal Codification and Reform Act of Zimbabwe, which is the code that has been used by Parliament to codify all crimes in Zimbabwe. So you talk of assault, is there verbal assault or physical assault, murder, it is contained in the criminal code, including hacking computers is a criminal offense, including issues to do of cyberbullying. They are criminal offenses contained in our criminal code and not the Cyber and Data Protection Act. So when you cite sections 160, the moment you start talking about 160, you are not in the Cyber and Data Protection Act, please. You are in the criminal code. And the criminal code is administered by the Ministry of Justice and not by the Minister of ICT, Postal and Courier Services. So if we've got issues with the provisions in the criminal code, it is important that we know the relevant stakeholders to engage. We also report accurately on the status quo in our nation. We also got consent a month ago as Potraz, the media, on the social media platforms. It may not necessarily have been the seasoned media professionals, but we have media that are operating as individuals, some is operating as media houses, talking about Zimbabwe having a standalone Cyber Crimes Act and so forth, which is not correct. So it's important for us to appreciate, to send the correct and accurate message there. The act also was used to amend another act of Parliament, which is the Criminal Procedure and Evidence Act. Prior to the Cyber and Data Protection Act, electronic evidence was not admissible in court. So the Cyber and Data Protection Act, when they were promulgating, they saw an opportunity to also amend the Criminal Procedure and Evidence Act so that electronic evidence can be admissible in a court of law. And also issues to do with expedited preservation to facilitate law enforcement were included in that amendment. But that doesn't make the Cyber and Data Protection Act the Criminal Procedure and Evidence Act. Neither does that make the Cyber and Data Protection Act the Criminal Law Codification and Reform Act. The act was also used to amend another act, which is the Interceptions of Communications Act. So the Interceptions of Communications Act was amended to provide for a cyber security committee and a cyber security center, which was intended to help us as a nation, because when you look at the composition of that cybersecurity committee, even talks about representations from civil society, representatives from ministries and so forth, so that together as a nation, we strategize on how we can best secure the cyberspace of our nation. In that Interceptions of Communications Act, it also amended the functions of the Cybersecurity Center by introducing a Security Operations Center that is responsible for identifying cyber threats at a national level, reporting these, taking initiatives or actions to make sure that we minimize cyber threats as a nation. Because we are not immune as a nation from cyber threat actors, because where we live is a global community and internet knows no boundaries. Likewise, cyber threat actors or cyber threat factors know no boundaries. So, I've spoken about these principles. My colleague is going to talk about the rights, data protection rights. I've spoken about the right to privacy, which is in section 57 of our constitution. I'm going to talk about what I mentioned earlier on, that the right to data protection and privacy is not absolute. There are certain limitations to it. And one of those limitations, and these limitations do not just apply to media houses, because the Data Protection Act is not just targeting media houses, it is targeting every institution that processes personally identifiable information. Because all of us in here, we have bank accounts, we have EcoCash accounts, NetCash accounts, OMARI accounts. Our data in that process is being processed. So it's targeting all those institutions that are processing our PII. So these exceptions that are applicable to the application of the principles that I mentioned, to the right itself, so they limit that right. So for example, I have a legal claim against manager. I don't need his consent to file court papers, right? So I can collect his information and make sure that it's in my founding affidavit. Mr. Komre Manage, who resides at number what? I've collected, isn't it? His home address, his name, his national ID, maybe in some cases. For me to defend a legal claim, he's owing me $1,000. So I can take his name, his surname, his home address to the magistrate court without his consent. Okay? So in that case, when I need to defend my legal claim, I don't need the consent of the next person, because I am limited, or I am exempted from the application of this act if I have to defend my legal claim. So that's one limitation. If I have to meet a legal obligation by virtue of a law in Zimbabwe, for example, ZRP needs to prosecute. I've stolen someone. He doesn't need my consent to enforce the laws of Zimbabwe, because he has a constitutional obligation, as well as a legal obligation in terms of Zimbabwe Public Police Act, to make sure that they arrest me, make sure that I've gone through the prosecution, and that justice is what is achieved. So by virtue of the Zimbabwe Republic Police, they can collect my PII without my consent, because right? So by virtue of a law, if they have to meet their obligation of law enforcement, they don't need my consent. If you need to protect the vital interest of the person, you probably don't need their consent in some cases. For example, let's say I have a challenge and I need to get medical attention. You may be able to say, I know Miss Mariwo is diabetic. You may have to disclose so that I get the help, isn't it? Because it has to protect my vital interests. If you don't disclose that I'm diabetic, so that I get better. So that is also, so you have disclosed my health status to the next person without my consent, but it is made to protect me as a data subject. If you are performing a particular task in the public interest, the media, you have a role to make sure that Zimbabweans have access to accurate information. If you are protecting your legitimate interest or promoting your legitimate interest as a controller, for me to be able to do business, but of course, you need to make sure that you justify that legitimate interest. You need to do archiving, scientific research, or historical reporting. You can keep that information. Maybe later on, ndazoita CEO weimwe company, Potraz Director, and you can do it. Makambo report about me before. Oh, she was talking about data protection. Then 5 years from now, I become a founder and CEO of my own company. Oh, Miss Mariwo, who was the director of data protection 10 years ago, is now the founder and CEO. Historical reporting, which is accurate. That is also allowed. Okay? Yeah? Household and personal use. If you collect PII for your own use, my family group, you can collect PII for your personal use. My groups now, Egumuri, Ekuma former students, associations, use. We can collect for household and personal use. So I just provided also a provision from our regulations which speaks to exemptions for journalistic purposes. Our law actually says if you are a data controller and you process data for journalistic purposes, for example, historical and archival purposes, for law enforcement purposes, for personal, family, and household affairs, you are exempted from applying a data controller license. So, as individuals, for purposes of our household use, for purposes of our family use, and for purposes of our personal use, we don't need to get a license. And for journalistic purposes only, as well as for law enforcement purposes only. But there is a catch, right? If you are law enforcement, if you are a journalist, you may be exempt from licensing for those purposes only, but you are not exempted from complying with certain data protection principles, which I've spoken to above, right? So you may not need to apply for a license. So I just thought it's important also to talk about the key elements of exemption from journalistic purposes. The data is only processed for journalistic purposes, not for human resource recruitment, not for your media advertising department, right? With a reasonable belief that the publication itself is in the public interest, with a reasonable belief that compliance with those requirements of consent or a principle would defeat public interest demands. So when you collect my personal information without my consent, and where sometimes you intrude or breach my privacy, you must substantially demonstrate that is in the public interest. And I'm going to come to where we are making recommendations to the media to say, when you are determining what is public interest, you need to document and outline it in your standard operating procedure so that when the regulator, because we are going to be approached by data subjects as the regulator, we have that responsibility in terms of Section 6 to investigate, to receive complaints from data subjects about data controllers whom they think are abusing their personally identifiable information. So as media houses, you are not immune from such complaints being sent to the Data Protection Authority. And we are advising you, this is why we are having this engagement. Do you have policies and procedures that help you determine what is in the public interest? How do you follow those procedures up to the editorial process? Because those are what we are going to look at when we investigate these cases. Whether you are compliant, have you trained your staff on data protection issues? Those are issues that we are saying as a media, as we engage, you need to put in place certain measures to make sure that you are in compliance with the Cyber and Data Protection Act. However, when it comes to very sensitive data, which is somebody's biometric information, health data about someone, genetic data about someone. Everyone, every data controller, including the media, the Act prohibits us from collecting that data and publishing it without the written, underlying written consent of the data subject. Because it goes to the root of my dignity as a human being, which is Section 61 of the Constitution. And the Constitution actually provides that there are no limitations to the right to human dignity. Once you breach it, you have breached a constitutional right that cannot be derogated from, unlike the right to privacy and right to freedom of expression. So you must give, when you process someone's biometric data, their facial recognition, or their pictures, their health data, their genetic